Okay, so I will warn y'all. I am teaching remotely tonight. Tim is under the weather, and so are several of the students who usually come to class, and I didn't want to teach an empty classroom, so I'm remote today as well. But that also means that we have to contend with my dogs that will periodically bark. With the weather being a little bit cooler, more people are walking up and down the street, and my dogs take offense to that because they're like the neighborhood, and there they go, the neighborhood hall monitors. So I apologize for that up front. So did anybody want to tell us what they did last week? Did y'all do anything fun? Did you take Wednesday to make yourself feel human?
I took the family to the fair,
Oh,
so
fun.
and other than not feeling like fall, like it should feel like when you go to the fair, it was nice. So
Good.
we appreciated they appreciated me being around, so that's great.
Sure. Well, Robin, sometimes not doing anything is some of the best times ever. Okay, William, yeah, dissertation was probably useful but not fun, or it doesn't sound fun to me. I had just gotten back in town. I got back in town late Wednesday from a conference, and so I was able to actually have dinner with my boyfriend. So that was nice. And sometimes it's just nice to have a change of pace. So again, I hope everybody did something that makes yourself feel human, even if that was not doing anything. So like I say, Tim is under the weather and he normally teaches this week. So y'all have me and we are going to fumble through this, but it's going to be okay. Neither one of us have started your assignment three grades, but we will try to start working on those this weekend. So far, though, everybody, has seemed to be doing okay. But again, if y'all have any questions, Tim or I are always available, um, via email to answer questions or give you some guidance or whatever. I know that there was a couple people that emailed us, I think Wednesday morning, the day the assignment was due, and I had been, or between traveling and Tim teaching, we weren't able to do it. So try not to wait to the last minute if you do have questions. But before we get started, are there any other questions? Okay. All right. Everybody should be able to see the screen, right? Okay. Okay. So this week we're going to talk about identity management, privacy by design, and privacy training and awareness. And so our ideas, like we've talked over the course of the semester, our ideas of privacy come from different forms. Um, Today we're going to look at some that deal with privacy in law enforcement and privacy in government records, as well as look at identity management practices, privacy impact assessments, and how to incorporate privacy by design. So, privacy in law enforcement, we're all familiar with the Fourth Amendment, the right for people to be secure in their persons, house, papers, and effect against an unreasonable, that's the key word there, unreasonable searches and seizures. This comes from the Constitution. We are all guaranteed this. So, how the Fourth Amendment works, if I was to come and go through your bag, that is not a Fourth Amendment violation because, in order for the Fourth Amendment to be applicable, the government must engage in search and seizure in order to do it. So, me coming to go through your bag is obviously a violation, but it is not a Fourth Amendment violation. And this is an important distinction. We talked about it a little bit earlier in the semester when we talked about HIPAA and how it applies to certain entities. If I ask you your vaccination status during COVID, that is not a HIPAA violation because I am not a covered entity. Now, if I'm asking on behalf of your employee benefits division, that might be considered, or if I tell someone else and on behalf of that employee benefits, that might be. But it's important that it needs to be a government actor. So if it is a government actor and there is a search, If you have a warrant supported by probable cause, then it is generally considered reasonable. Probable cause exists when a reasonable person would believe that a place to be searched will turn up evidence. If you do not have a warrant or you do not have probable cause, it's deemed unreasonable. And again, there are exceptions, like if it's in plain view, if there is an emergency, exigent circumstances, if the police come to your door and they don't have a warrant, but they hear somebody on the inside, hollering for help, or there was a fire because there's smoke billowing out of a window, they can enter your house without that being considered unreasonable. If a search is deemed to be unreasonable, any evidence that they find at that point is inadmissible, like in a court proceeding. It's called the fruit of the poisonous tree. So if they come to your house, they don't have a warrant, there's no exigent circumstances, they open your door and enter, and they find, drugs or guns or whatever. There was no warrant, there was no exigent circumstances. So that would be considered unreasonable, and any evidence, those guns, those drugs, or whatever they found would not be admissible in court against you. Okay, so here's a few of the key Fourth Amendment doctrines. There's the third party doctrine, that if a person exposes information to a third party, then you can no longer expect privacy in that information. And this is important for, while slightly different and not a Fourth Amendment, if you go to talk with an attorney, you have attorney-client privilege. But if you bring a third party, your friend in there with you for moral support, well, it somewhat negates that idea of privacy because you've brought in a third party. Or if you give your documents to a third party, then you cannot necessarily expect those to be private. The misplaced trust doctrine. Basically, this is the informant and a snitch, and people always say, well, if I ask if you're a cop, you have to tell me, and if you don't tell me, then it's not admissible. That's not true. So just because you told somebody some information or sold drugs to an undercover officer or an informant, you don't have any right to privacy in there. Plain view, we talked about that just a second ago, that if, a police officer pulls you over and you have, drugs on the seat of your car in plain view, that's an exception. It does not trigger the Fourth Amendment for an unreasonable search because it's not a search. You can see it. Also, the special needs doctrine. This is when, like, non-law enforcement need a search to be reasonable. This is like your kids go to school and somebody says they brought drugs or a weapon or something and it's in their locker, and the school officials will go and look in the locker. They have the right to do that because they have reasonable belief that it is there. So when it comes to technology, times have changed. It's not just about getting into your house. So what about like all your iPhone or, Android or all your digital information? And this is important the more and more that technology comes about, ISP providers, email servers, things of that nature. So Riley versus California, this was just 2014. A warrant was required to search digital information on a cell phone when it was obtained through somebody's arrest, because it's not just a physical paper or effect. It differs than that because generally it's like locked. You have to have a passcode or something like that. So you have to have a warrant unless there's, again, some kind of exigent circumstances. They've kidnapped somebody, it's something of that nature. But you have to have a warrant. So even if you get arrested, you do not have to give a police officer your password or Face ID to be able to get into your phone without a specific warrant. In 2018, there was a case dealing with the cell site location, and it does constitute a Fourth Amendment search because you have a reasonable expectation of privacy in your physical location. The third party does not apply. But this is where they would triangulate where you're at, like if they're trying to track down somebody who's been kidnapped and they're pinging their phone and they want to kind of triangulate where they're at. That might be considered an exigent circumstances, but typically they need a warrant to be able to get that information. Okay, so in the state, the states all have different electronic surveillance policies. Typically, if one party to a communication consents, then it's okay. This is, nowadays, have you noticed accidentally turned on the iPhone where it says this call is being recorded? They do that because some states require both parties to consent to recording a telephone conversation. People violate these all the time because they record conversations. They record on their phone, maybe in a doctor's office or, a school hearing or, with an ex-spouse or soon to be ex-spouse. Happens all the time. But if you call, so Arkansas is a one-party state. So if you call me, I can record the conversation because I consent to it being recorded and you never have to know. Of course, if I do it on my iPhone, it'll tell you. But however, if I'm calling someone, one of you online that lives in a state to where all the parties have to consent, you're always going to go with the most strict one. So everybody would have to consent for my recording to be legal and admissible. Otherwise, I violated the law. Does that make sense? Okay, so here's the law in Arkansas regarding recordings, whether it's a phone or just, I'm recording my drug deal or something like that. One of the parties, only one has to consent, which generally, if I'm the one that's wanting the recording, that's a very easy burden to meet, because if I want the recording, then of course I'm going to consent to it. And if for some reason you violate this, it's a Class A misdemeanor. Okay. So this is the banner that the Justice Department uses when you go to log on to the computer every day. It says you're accessing a government information system. It's restricted to authorized use. Unauthorized use can result in disciplinary action, and it can be monitored. We also use VoIP phones and read electronic monitoring. So if we use a VoIP phone that runs on the network, and this is the warning when you log onto your computer, can the government, my department, monitor or record telephone conversations because I clicked OK to log on to the computer? What do you think?
No.
Let me see. Let me check the chat here. It's an iffy one. I'm going to say no, because even though the phone is going through the computer from a VoIP on the network, I think there's a difference in I'm agreeing to log on to the computer and know it's being monitored, but I don't necessarily know that my phone calls are being monitored. So I'm going to say no, but it's kind of iffy. All right. Does anybody have any other thoughts on this? Everybody ready to just get through this lecture and get home?
I'm coming off mute. So
Okay.
a new Teams feature that we've implemented at work is if we want to record the team meetings, it puts a lock on it. So everybody has to turn their mic on, turn it off, and it gives you approval.
Yes, I know in Zoom, there's a thing that says, hey, this is being recorded. Basically, if you don't consent, get off now.
Right. Right, but you can't
So,
even talk on it if you don't agree, if you don't enable your mic and then disable it again.
oh, okay. But I mean, at least that way, affirmatively people are aware and they can choose to participate. And that's probably some of the problem is when you're on the phone, if Arkansas is a one-party consent state, so only I have to consent to my phone call being recorded. But if I pick up the phone and I don't know it's being recorded, and the party I'm calling, which is not the government necessarily, they don't know it's being recorded, then neither one of us have given consent to it being recorded, which is why I say it probably does not, this warning banner probably does not cover telephone conversation monitoring because neither one of us have given an affirmative consent. So I do think it's good though that everybody has to consent in order to participate on Teams or Zoom because because we're really moving in that direction. In fact, I was looking at okay, sorry, I had to yell at them. We were talking today at work about like Microsoft Copilot, you can send your chat bot to a Teams meeting. And then your team, it'll pretty much transcribe everything that happened in the Teams meeting and then send it out to everybody. But that's essentially a recording, but I don't know that everybody knows that. So I think that's probably going to be another one of the things that's going to be coming up at some point is looking at when you send your chat bot to your Teams meeting, or there are other tools outside of Copilot, but when you send your AI bot to your Teams meeting for you and it recording and transcribes it and emails it to all the participants, do they know they were being recorded? Because that's essentially a recording. So it'll be interesting to see how that plays out over time. Okay. Okay. With regards to stored communications, these are like your emails, things of that nature, maybe your Dropbox, it might be applied to that. I'm not as familiar with this law as Tim would be. But there's a process for which the government can get under the Stored Communications Act for law enforcement. This is for data stored abroad because, nowadays, I mean, I have no idea where my email servers are store my data. For the government, we can say, I only want to use data centers that are located in the continental US, but, inevitably, a lot of people use data services all over the place. Okay, I'm sorry. That was my dogs again. They're frisky. The weather has them frisky. So anyway, so we don't know necessarily. I mean, I've never bothered to look where my servers are stored for any of my email services. So companies that are providers of electronic communication services, again, these are your Dropboxes. I mean, it could be your Amazon Web Services nowadays for remote computing services. It's your, OneDrives, it's all those kind of things. So the U.S. companies that are served with court orders under this federal act have to turn over data as long as it's within their possession, custody, or control, regardless of where it's located. They cannot say that, well, I can't get to it because they're in France or they're in South America or wherever they would be stored. So this is how law enforcement can get those records. So under the Communication Assistance for Law Enforcement Act, requires telecommunication carriers to design their networks in a way that makes them compliant with requests for government surveillance. These are your Verizons, your AT&T, And they can't say, well, our network doesn't support this type of surveillance. Should there be a warrant or a reason under this act to get it? Telecommunication providers, they have to be able to isolate and intercept electronic communications and deliver them to law enforcement. These are things under Homeland Security can use these things. There's a lot of reasons in which they can do that, and carriers have to facilitate that. They can't say, sorry, our network doesn't support that, or we can't do it. It requires them to do so. And again, as the world becomes more and more interconnected, I think it makes sense, because people will also try to use their network configuration, their network design, their server locations as a way to not have to comply. And these two acts ensure that they have to comply. Like, you can't intentionally keep your data server just over the border in Canada, so then you can say, sorry, it's not in the US. And these things are, of course, used for, all kinds of, terrorism. These things are used for, like when we've seen a school shooting, you've got the Ted Kaczynskis of the world, all these federal crimes. These are the laws in which they've been able to provide these records. Okay, government records. This is often the bane of my existence. So the government has tons of records, of course. You want to make it available to the public. So again, because the government is responsible to its constituents, right? But yet at the same time, the government does have personal information. So there's a privacy implication interconnected to the right of knowing what your government is doing. So the court has certain privacy rules for court data under Administrative Order 19. And both federal and all states, Arkansas has probably the most, one of the most, if not the most broad Freedom of Information Act, where you can send an email or make a phone call or fill out a form that says, I'm requesting all emails, records, documents pertaining to whatever topic. Or you could say, I want all emails to and from Jennifer Davis from October 1st to October 5th. And we have to provide those to you. We are under a legal obligation to provide them. However, we also have a legal duty to provide redactions to personal information. There are multiple exemptions in the Freedom of Information laws, at least for the state. It includes home addresses of state employees. Like right now, salaries are online. Hey, stop, y'all. Hang on. I'm sorry. We've gone to school today, and now they've eaten dinner, and they're starting to feel a little frisky before they're going to crash out. So I apologize. Okay, so under the Freedom of Information Act, I have a duty to provide the documents you requested, should they exist. Now, the Freedom of Information Act does not require me to create a record. But if I can reasonably pull one, or we have one, and oftentimes this comes in like we have one person that requests invoices or invoicing data for a period of time, and they want certain fields. Well, I would have to go in and create the report, or I could just go in and download all the invoices for such and such dates, and they either get all the fields that are listed, but I don't have to create fields that they want. Or if they, if a requester wants a reason or are asking questions, that does not fall under the Freedom of Information Act. Like, I don't have a legal obligation to answer questions or explain things. It's just a flat providing documents and records, which is emails. It could be, we've had paper records. It means reports. It means, anything that we have, Teams messages, people using chat, all of that is considered FOIable. But I do go through and redact it. So the exemptions include personal information. I redact also passwords on Teams meetings or Zoom meetings that may be set up, because those show up in email and it might just be a one-off meeting. But if it's a regularly occurring meeting and someone has that password, then they can get to it. Personal email addresses we redact. I went through the FOIA handbook the other day looking for a specific exemption. There wasn't one listed, but there's law enforcement. Obviously, we're not going to give out the names of our law enforcement undercover because obvious reasons. We don't give out critical infrastructure. We don't give out disaster recovery information. We don't give out information about water utilities, which interestingly enough, there's multiple, I don't know what happened. There's something must have happened one year and they put in several exemptions for water utilities. But there's no exemption for the remaining critical infrastructure. However, though, there's no exemption for necessarily building plans. I had a FOI for 2 years ago where there was some renovations when our new governor was elected. They were doing renovations on the mansion to accommodate her family, because it's the first time we've had young children in the governor's mansion for quite a number of years. And so they did redact. I mean, we did these FOIs for these, and one of the building plans. Ouch. Sorry, the dogs are really I've had a really crappy day today, so y'all are just gonna have to forgive me. But it's okay, we're gonna get through this. But the building plans that were included in this FOI include the schematics of the exterior of the mansion to the, they were the blueprints, how thick the walls were, the material the walls were, things of that nature. So we redact those out of general security concerns. We obviously don't give out the layout to the prison, things of that nature. While there's not a specific exemption, I always follow the general privacy. And if somebody wants to take us to court and a judge would say, fine, you have to release it, that's okay. But once you put the cat out of the bag, you can't get it back. So there's a balance there. So yes, you have a legal right, not constitutional, legal right to know what your government's doing, but yet we still have to hold things private. There's a balance. Let me check it. Yes, I didn't see this earlier, but yes, don't route everything through AWS East. It was a nightmare. Thankfully, we weren't affected, but it was difficult. Okay, we covered this. Arkansas FOIA, public record. It's a writing record, sound, film, tape, electronic, computer-based information, or data component in any medium. So we've had to give out, like we did drone videos we had one time, things of that nature. We don't have to create them, but if we have them, we have to give them. These are just some of the exemptions, medical marijuana facilities, grand jury minutes, things of that nature. All right. So this is a new FOI exemption at the federal level. So not state, but federal level, that protects, it exempts certain kinds of information for critical infrastructure, which again, the fact that it didn't come out till 2002 is surprising, because you would think that you want to keep your critical infrastructure even more so now, under control and protected. And this is oftentimes not just, your electricity, your water, like we have Nuclear One, the nuclear reactor here. But there are sometimes critical infrastructure can include like some of your agriculture and stuff like that, because if your food source is interrupted, we have problems. And I will tell you, our chief security officer was in a Homeland Security briefing not too long ago, and he was talking about the critical infrastructure, about how if people only knew the amount of attacks that were regularly tried to get housed at our critical infrastructure, he said people would be terrified. And it terrifies me thinking about it. So I just like to think that we have good security operations going, because it is terrifying if all of a sudden we live like Little House on the Prairie. I couldn't survive. Okay, so we talked about this maybe in the first or second class, the Privacy Act of 1974. This was really the most national, that we can say, privacy regulations that we've had. And it regulates only at the federal level. This is a federal law, and it regulates the collection, use, and disclosure of personal information or personal data. It's important to note that in 1974, of course, it predates all of our information technology, and the amount of information and the ease at which we collect it. This was before that. So while it does, the privacy rules still apply regardless of whether it's in paper or, microfilm or electronic form. But we all know that IT has accelerated the amounts of data that are out there and available. So it applies to federal agencies only. It does not apply to state or local governments or anyone else, except for as it relates to the Social Security number. But it essentially applies to citizens of the United States or aliens lawfully admitted for permanent residency. The FOIA in Arkansas, as well as the federal level, applies to any person. So regardless of your immigration status, you can be a citizen of a foreign country and still do it. In Arkansas, the only requirements are you cannot be a felon currently incarcerated. You can be a felon, but you can't currently be incarcerated. And you have to be a resident of the state. Otherwise, you're eligible to get a FOIA in Arkansas. But the Privacy Act applies to records contained within a system of records that must be identifiable to an individual. The record must be kept as part of a system, which is a group of records retrievable by a person's name. So in the IRS, you can go out there. A record is my 2024 tax return, but it's part of a whole system of records under Jennifer Davis for all my tax returns from all the years in which I've submitted them, along with any other documentation that the IRS may have on me. They might have payment information from where I've paid taxes. They might have refund information from where they've sent me refunds of my taxes. So all those things that relate to that is considered a system of record within the IRS, and they have to protect it. Social Security number is a unique set of personal data, because it prohibits any federal, state, or local agency from denying an individual any right, benefit, or privilege provided by law because of refusal to disclose their Social Security number, which I find interesting because pretty much everything asks for your Social Security number nowadays, although they've gotten better and maybe just ask for the last four. But I mean, when I first started at ULR 100 years ago, but it was before they went to T numbers, and my boss login was my Social Security number. So they used to use it on everything. But if you have to disclose your social security number, if it's required by law or by statute, or I can use it in a different way to verify my identity if I voluntarily give it. Consent trumps everything. So if I consent to give you my social security number, then that's okay, but you can't require it. And they've gone away from the use of it because it is so high. It's very highly protected. One social security number, one person. And while it can be changed in your lifetime, I think there are very limited circumstances and a very high burden of proof of what you have to show to be able to say, I want a new social security number, because otherwise people will just like run up credit card debts, run from the law, things of that nature, and use it to change their identity. Okay, so the driver's license. In Arkansas, driver's license information is protected under the Driver's Privacy Protection Act of 1994. So it's been around for a while, and it regulates the collection, use, and disclosure of motor vehicle records. Basically, we cannot knowingly disclose personal information in your motor vehicle record for a purpose that's not permitted under this. And nobody can go and just get it. Like, I can't go and just request a list of all my neighbors' driver's license information. So again, I can consent to give you my driver's license information, but a creditor can't go and get driver's license information without my consent. I will tell you though, and I shared this, I think, the first day of class. My dad had his identity stolen a number of years ago. And he had it stolen because a lot of people don't think your driver's license, because we have to whip it out all the time at the, grocery store, the liquor store, to go in the casino, to check into a hotel. Sometimes we think about it as not dangerous, right? Because it's not our social security number. Our address is available online, so we don't think about it. But my dad's ex-wife, and her new boyfriend took a copy of my dad and my former stepmother's marriage license, along with like one of my dad's insurance cards, to motor vehicles in Mississippi. Said they just moved there, needed a new ID, and Mississippi issued this man a driver's license in my dad's name. It was a valid driver's license. Issued through the state of Mississippi, so it wasn't a fake ID. Like we did when we were kids, kind of fake ID. It was a valid license, but it was this guy's picture in my dad's name. The man had gotten arrested multiple times. He had vehicle accidents. I know he had at least 2 DWIs in Kentucky that I'm aware of. He worked under my dad's name. He had probably several $100,000s of life-saving surgery in my dad's name. My dad was alerted when he got an email, or he got a letter from the IRS saying that he didn't claim all his income on his taxes because the man had worked in his dad's name. So my dad lives here in Arkansas, and this man got the driver's license in Mississippi, but he worked in Tennessee, arrested in all these places: Tennessee, Kentucky, North Carolina, and Virginia. So there's no one place that my dad can go, again, look at and say, well, where are all the places I've worked? And so we were alerted that there might be an issue, but again, there's 50 states. We didn't know where to start. Eventually, the hospital in which this person got hundreds of thousands of dollars worth of life-saving surgeries, and the bills didn't get paid. So I guess they eventually traced it back, my dad's address, back from his credit report. And my dad started getting all these collection notices. And so it took us years to get it sorted out, because, if you call a collection agency and say, oh, well, that's not my debt, I didn't do that, their number one thing is like, yeah, right, you didn't. But I had a file I just kept, and I would send them like, here's a copy of my dad had a hard time getting his driver's license in Arkansas again. But here's a copy of the fake driver's license, the real one, all these things, police reports. The guy was eventually tracked down to North Carolina, where he served time for stealing my dad's identity. But so we don't think of our driver's license as that important, but it is. So you should protect it, because somebody could use your steal your identity with it. Here are some permissible uses for the driver's license. Government agencies, motor vehicle safety, stuff like that, insurers. Okay, let's get to the main thing tonight: privacy by design. I'm not going to pull up this video. I'll let you guys do that, or it's a link here. But it was developed by Anne Kevoian. I'm not sure if that's how it's pronounced. And what it is that data privacy and design and protection should be built in and inherent in your technologies throughout their life cycle. Any information, personal information that's in an application, it's applicable to. But when you have sensitive data, it really needs a more rigorous application, because the more sensitive data, then, you want to protect everything, but you need extra eyes when it's extra sensitive data. And your privacy, as we've said, if you build it in the front end, then it's easier to protect than trying to retrofit privacy into some of these legacy systems. And so if at any point in time, you need to start some privacy by design, you may not be able to get to every system you have, but as systems go through upgrades and things like that, you can start this. So it's a proactive, not a reactive measure, which, most companies, at least the government, we operate reactively. But privacy by design is characterized by proactive rather than reactive measures, and it anticipates and prevents privacy invasion events before they happen. It doesn't wait until after they've happened, but it tries to prevent them from occurring to begin with. It's basically the cybersecurity, endpoint management. You try to prevent things from happening before they become an issue. Privacy, while it's not new, it's still considered an afterthought. It is not the default. And so it needs to be built into the default. And privacy by design seeks to maximize the degree of privacy by ensuring that personal data is automatically protected in the systems. So if it's embedded into the design and the architecture of the system, not an after the fact thing, then it becomes an essential component of that tool being delivered. And it doesn't diminish any of the functionality. This is one of the issues for, we had I think it was like an old mainframe type process that would print out letters to, I think it might have been people who have a liquor license or a license to sell cigarette tax, the stamps and stuff, something of that nature. It was an old mainframe process that would run these letters. Well, they moved it off the mainframe. However, this would have been an opportunity that if you looked at the process and did a privacy by design from the front end, obviously they couldn't do it on the old legacy mainframe system. But they didn't do it when it was modernized to a newer process. And what happened is there's two people on the letter, like the primary and the secondary license holder. So say I'm the primary, Tim's the secondary. What happened is the primary's last four of their social is on the letter. But they put the secondary person with the primary last four of the social security number on there. So it was like off one. And they didn't notice it until these letters had already gone out. Thankfully, because the people that were involved, they were involved together, they would have both had the information. It wasn't that big a deal, but it could have been a big deal because they just assumed they modernized this process, they hit print, these letters printed. But they didn't do this testing. So if you do privacy by design and went through this assessment, then what you would have seen is, okay, this has last 4 digits of social security number. So this should trigger something that we need to test in the outcome. Is it protected? How do we look at this? Are we collecting? I think it might have had the full social security number. I think it did on those letters. But that was an opportunity after the fact that we said, do we really need the full social? Can we use the last 4? So privacy by design would have picked some of these issues up beforehand. And it wants to accommodate legitimate interest, but to do it in a right way, to make sure that you're not unnecessarily trading off things, and you want it to be win-win. And so it's important that you put this privacy, if you ask a few questions up front, then it makes it better on the back end. Okay, so end-to-end security, the full lifecycle protection privacy by design. If it's embedded into the system before the first element of information is collected, it extends securely throughout the entire life cycle of the data involved. It ensures that you have those security measures that are essential from privacy from start to finish, and ensures that data is securely retained and destroyed at the end of the process. So it's kind of a cradle to grave thing. And it seeks to assure that all stakeholders, regardless if they're in business or technology or whatever tool is involved, that everybody is operating under the promises that you've made in your privacy policies. You say, we will protect your data. Well, a way to protect your data, customer data, is by doing privacy by design. Because if you're not building it in up front, then it costs more money, time, effort, or you might not be able to retrofit it. If you've always gone with social security number and you have a legacy app, you might not be able to go in there without breaking that app. And like Tim and I say, this is my parenting style: trust but verify. So privacy by design, another component is that it does respect user privacy. It requires that everyone, from the architects, the operators, the business developers, the project managers, everything, keeps the individuals and the protection of their sensitive information the utmost response to privacy for that information of those people. You want to keep it about the user. The goal of the system is to modernize something or to build something, but ultimately is to protect your customers, your citizens, yourself, whomever. This video, I'm not going to play it, but it's really good, so I encourage you to go back and watch it. It's only 3 minutes and 30 seconds. So it's not very long, but I do encourage you to watch it. Okay. So GDPR does require privacy by design, which is another big difference. GDPR is pretty strict, but it does require this privacy by design. It says, taking into account the state of the art, the cost of implementation, the nature, scope, context, and purpose of processing, as well as the risk and severity, the controller shall, both at the time of determination of the means for processing and the time of processing itself, meaning both when I'm figuring out how I'm going to do this and while I'm doing it, you must have appropriate technical and organizational measures to protect and safeguard against people's personal information being released. Only personal data which is necessary for each specific purpose is processed. We talk about don't collect more than what you need. Privacy by design would be a way for you to determine, what do we need? And if somebody comes to you and says, I need an application that I need social security number, bank account number, I need, name, address, phone number, I need blood type, and, I need this. A privacy by design questionnaire would look at all, this is the data being collected, and you would look at it and say, do we really need the blood type? This is a credit card application. No, you don't need blood type. It's not pertinent, so don't collect it. It might say, is it necessary to have the whole social security number, or can we go with the last four? Things of that nature. Or if you're upgrading a system, or you've got a new module, or you're doing a redevelopment or something of that nature, you would go back through it and look at those things and say, the system collects these 20 pieces of personal information. Is it still necessary? It may not be anymore. Times change, much like, at one point in time, certain things at ULR required your social security number to log in. Well, then it eventually moved to the T number because they determined it was more secure, because your T number was shown a lot and available to people. They didn't want your social security number being out there. So it's a time for you to reevaluate to determine, do we still need these things? And the same form and the same, privacy impact assessment can be used whether it's a new development or a modification, because it's going to look at what do we have and is it still relevant, and are there better ways of doing it? Okay. So identity access management. I will tell you, this is not, I get it, but this is Tim's bailiwick here, but it's how we determine who's the user of a system or not, and whether we have appropriate authority. This is for those of y'all who either work for the federal government or have to deal with anything. Logon.gov is, being used more and more to where, and I'm sure you've all encountered, whether it's logon.gov or something else, to where you have to upload your driver's license and then you have to take a selfie and it compares, because that even cuts down on people using someone else's username and password when you have to do that. So how identity management works in the real world, it's everywhere, and it's often tied to another application, which is really dangerous. So like your fantasy football through CBS, which is now ESPN, you can log in using your Facebook user information. Well, what happens if somebody gets my Facebook information, or somebody logs on and gets my fantasy football? Then they've got access to both. So it's happening all over. Okay, so users may have different roles with different levels of authority. So it's, I have, let's look at Thomas. We'll use him as a perfect example. Thomas is a student in this class. So when he logs into Blackboard, he has authority as a student in this course. But he's also a professor. So he logs into Blackboard and also has authority to see educator modules and to be able to administer his courses. So one user can also have multiple identities within a system. So it's important to identify those. If you use a federated identity where you can use it's your single sign-on for multiple applications, we caution against this because, again, if somebody hacks into your Facebook and gets your Facebook information, but yet that's how you also log on to your email, or that's how you log into some other system, then they've gotten access to both systems. But, most people do that because it's easy. They don't want to have to remember a second password. Okay. So what are the benefits? Let's talk about this. What are the benefits to consumers of a strong access and identity management? Let's use logon.gov, where you have to, instead of having a username and password to log on to a federal system, you have to have your selfie and driver's license verified, and you log in via that. What's the benefit to a user of that system from having to use it that way? Does everybody feel like I do today? It's been a long day, crappy day. Go ahead, Thomas.
I was just gonna say, sorry, could you repeat the last part of the question?
Okay, so again, if you're going to just say you're going to go log into the Social Security Administration application, they used to have a username and password, but they've gone to the logon.gov, and you logon.gov looks at your, face. You have to do the selfie and compares it to your driver's license to create an account. So then it makes you do all that. What would be a benefit to an individual by going to that kind of access and identity management?
It's one place for identity management for the consumer.
It is. It's one place, makes it easy.
Yeah,
You don't need to
but
have that many passwords too.
Exactly.
but then the requirements might not be easy. Like you said, it's sometimes easier to
Right.
recycle a password than to.
Right. Facial recognition, Jerica says, helps prevent fraud, and it does. I mean, it prevents somebody from logging into my account. What's the benefit to the IRS or the Social Security Administration or the system that utilizes that? What's the benefit to them to going to a system like that?
This protects them as well. I mean, it cuts both ways.
I would agree. But what are the disadvantages? We mentioned a minute ago, it's harder to get around than recycling passwords. But are there any other disadvantages for a
You-
consumer?
You lose your phone, you lose your access.
That's true.
Well, and
Or
and
if you're
every piece of data we share, that gets out in another system is available to be compromised and misused. I mean, it's just
right.
more and more.
Yeah, William says it's complex to set up, may be difficult for non-technical. I was watching my dad try to do a facial recognition one to where you have to or when he was setting up Face ID on his phone for the first time, he got a new phone. And you got to look up and slowly turn your head all the way around. I'm like, Dad, no, you got to keep going, keep going. So it may be difficult for some people. It may be difficult for people if you don't have a smartphone or non-technical people. It also makes it more difficult for my dad can't call and say, hey, can you log in and check and see what this is on my account or something like that, when normally that's something that he would do. So it makes it harder for people to assist. We'll say that.
And makes it harder for folks that are not tech savvy to use.
Very much so. Okay, what would be some disadvantages to the company, to the IRS, to the business, whoever's using it?
They need to adopt a system that is not part of theirs, so they may not know fully how it works and all of that.
You're right.
I mean, as custodians of that data, there's all sorts of liability that comes with that. I mean,
All right. All good, all good.
And maybe more people not using that service because they're trying to do the old route of physical letters and stuff like that if they can.
Right. Lack of technical knowledge or know-how, that's true. And I think it's especially true, while we may be fairly technically inclined. I mean, have you ever tried to help your parents do something on their phone? I mean, I remember even with my mom when she learned to use the emojis in her text messages, So
we talk about it all the time with our design students. I mean, you always have to assume that your end user is going to have a much lower, knowledge of tech, and you don't build for yourself, right? You build to that lowest common denominator.
Exactly. That is exactly true. And that's why even when it comes down to, like your privacy controls, you may have fantastic controls in place. But if somebody clicks on a phishing link, I mean, it's the lowest common denominator at that point. I think somebody said the other day that average we were looking at for like phishing campaigns, you want like a 3% or lower for people who click on the link. And they had done one and they were at 15%. So 15% of people that got this email clicked on a link. And so again, doesn't matter how strong your controls are if you're going to click on a link. So, and nowadays some of our phishing links, emails, you can tell immediately, but they've gotten good over the years. I mean, there's been a few to where I've had to really question.
Imagine if their backbone breaks down like the Amazon thing this week.
Yep.
Wow, it will be nuts.
I know. Or, what was it, a year ago when CrowdStrike patch went out that literally like crippled the airlines along with a lot of other businesses? And that's, one of the problems is, like so many people, not that Amazon is the only one, but when people are doing the AWS or they're using the logon.gov or they're using CrowdStrike, and so many people put all the eggs in the CrowdStrike basket or the logon.gov, because your logon.gov can be used, states can purchase that to use as well. It's not just a federal thing. If there is an issue with that, then a lot happens, like CrowdStrike. It was, all over. It was a worldwide global issue. And so that's what happens when you do that. So it can still happen, and all your eggs are in one basket. All right. I think this is the last section, so I will get y'all out way earlier than Tim will. So let's talk about some privacy training and awareness programs. So training is used to instruct people about what your policies and procedures are. But awareness reinforces that. So like, you may have to do your cybersecurity or your privacy training that says these are our policies, these are good practices, this is what we expect of you from an employee standpoint. But awareness is when you see the poster in the elevator or you get the email that says, just a reminder, here's an example. And it just kind of reinforces the topics that you got in training. There are certain days of the month, like right now, we are in National Cybersecurity Awareness Month, which is probably why so many people are sending out the phishing campaign emails. There's a Data Privacy Month that goes from January to February. Those dates I would have to check. That might be 2024 dates, but you get the general idea. And January 28th is International Data Privacy Day. So those are days that you can bring awareness to your teams, to your company about, hey, today is, Data Privacy Day. Here's ways in which you can protect privacy. Have you considered this? It might be a day that you might want to schedule for your office to have a, clean out day. It's Data Privacy Day. So we're going to clean out our desk. We're going to clean out all the filing cabinets, and we're going to put everything that we can that needs to be shredded into the shredder instead of just piling up everywhere. Things of that way. You can kind of turn it into a way to reinforce what you're telling people, because just doing training one time isn't sufficient. You've got to reinforce those concepts. There are multiple ways to do awareness programs: emails, Teams, webinar, posters, team building, lunch sessions, awards and recognitions. We did a phishing campaign at work yesterday, I think it was. And I was in a meeting and I remember getting this email and I was like, oh, so I clicked the report, not just deleted it, but I clicked the report phish, and it was like, you have done, you have passed our phishing campaign. And I was like, yes. And everybody in the meeting was looking at me. And then we were all excited. We were talking about it today about, I passed mine. Did you? And somebody was like, no, I didn't. So, I mean, it's almost kind of becomes a game like, yes, we passed it. So there are ways to, again, continue to reinforce it. And you can make it fun. Here are resources that are available. We use this KnowBe4 training at work, and the KnowBe4, like I think one of the trainings is, I mean, there's obviously larger trainings, but like a refresher, there's like a 2-minute training, and it's really good. I mean, in a short 2 minutes. So there's that. There's tips on how to make Cybersecurity Awareness Month a success. The DHS has a National Cybersecurity Awareness Month whole toolkit. So go watch these, utilize these in, you know, your offices. They will be good. All right. So should you build or buy your own training? We've been having this discussion at work on certain things. You know, do you have the time and the resources to develop a program? Do you have the funds? How will you do both? You know, we use KnowBe4, and so they have a, you know, you can buy a license that gets you like access to all these modules, but you can also work with them to build custom modules for you. You know, ones we're looking at right now rolling out are some AI ones, because, you know, everybody needs a general AI training, responsible AI use for the generic employee. Basically, don't put, you know, personal information or anything like that in a public chat GPT, you know, because, you know, they do. And so, you know, what is AI, how to use it? People think it's like a secure thing. So we're looking at rolling out some AI training. If you work for a public sector, there is also some other free training that for AI, as well as other things, that is for public sector employees, that is free. So let me know and I can let you know about that. Also, if you want to do more training, like, you know, I have a certified informational privacy professional certification. There's also a privacy manager. There is a, you know, AI governance. IAPP offers multiple certification trainings for you. They offer, you know, the information privacy professional, the CIPP. They have one for like Europe. They have one for the US. They have one for Asia. There's multiple different versions of that depending upon where you're at. Again, the privacy program manager. So if you're looking at getting additional certifications, IAPP is the place to go. You have to consider about training. We looked at this. We were talking about our phishing campaign. So if you fail the first time, they'll send you a link that says, hey, you need to do a little refresher training. It's just a short little training video. But if you fail a second time, you're going to have to do a longer training. And for people, because unfortunately there are some people who have failed a third time, at that point, we're going to bring you in for training because you're not getting it. So you have to look at really, how is that training going to be provided? You know, not everybody has the time, or not everybody's in the same location to be able to do a classroom training. But yet at the same time, classroom training is important because people have a tendency to, you know, to zone out during recorded or live training. And, you know, it's easy to leave it going in the background, but not really pay attention, or do some kind of interactive training. So you have to look at what are your needs, what level of training or where you're at right now. Is it a refresher course? Is this your initial, I'm just hired on as a new employee and I need to go through a longer training? That might be a better opportunity for classroom, or, you know, an interactive online training. If you're going to do something like, you know, just a yearly refresher, perhaps it could be a recorded video. If you're going to do a certification like at IAPP, would you be better off going to a classroom? They offer classroom in-person trainings, like intensive 1-week trainings. They have interactive online. You know, some of that's also going to be your learning style for those larger types of certifications. And how often should it be delivered? You know, it should be when you bring on a new employee onboarding, and then you should at least do it annually. But what does your policy say? Do we do it annually? If you're collecting a lot of information, you might want to consider doing it more frequently. Your regulations may determine it. I know if you work in an area that has HIPAA data, they require HIPAA training annually, and you have to pass a test. I mean, it's an easy one, but you still have to do it. So your regulations may determine that. Your laws may determine that. Some of it might just be your needs. When I worked at Department of Education, we did a general privacy, just a basic general privacy, not cyber. I mean, it kind of has some overlays, but we did a general privacy and Freedom of Information Act training once every 6 months, because people forget, and maybe not so much forget, but people become lax. And the more that you can reinforce those concepts, then the more people, start paying attention. Like, should I click this link, or should I report it, or should I not? I don't know what's going on. Let me go ask somebody. And should your training be customized to roles? We had this discussion very specifically today regarding AI. Not everybody in the company needs privacy certifications, but does the CEO need the general privacy? Absolutely. I mean, we talk about privacy being a culture, and it should come from the top down. If the CEO is not going through training, why should everybody else? I mean, the CEO has access to personal information. But do you customize it? Like, there is going to be certain roles, like who shreds the paper? Does somebody watch them shred it? Do they certify that it's been shredded if you have a company? People that work in HR, or people that work in employee benefits or in healthcare, they might need more specific training that's customized to their job role than maybe someone else. So you have to really look at, one size doesn't necessarily fit all. There might be a basic training that you can provide to people, but who needs additional training? Like perhaps the developers need specific training on, recognizing some of these privacy controls, especially from a legal or regulatory standpoint, from a technical side. Whereas other people might not see the magic that happens in that, but they see the output, so they need a different training. So keep that in mind if you're ever in charge of, or something to bring up for training. Okay, you got to have training metrics. Otherwise, how do we know how we did? This could be number of incidents, feedback, how many people clicked on your phishing link, things of that nature. We sent out 100 phishing link emails. 15% click the link. So we're doing poorly. So you have to have something to know how you're doing, because otherwise, what's the purpose? Okay. Here is an incident response plan. Exercise scenarios. Both of those links will be in this document. I mean, this PowerPoint. I'm not going to open those up. But they're exercise guides and planner handbooks. This will be important for you, because your next class, there is not a lecture next week. Oh, we're at the end. Next week is a work day only, because your incident response plans are due at 6 p.m. November 5th. So in 2 weeks. I can't believe it's about to be November. Merry Christmas, everybody. Your incident response plans are due in 2 weeks. So next week there will not be a lecture. We will have class open like we've done in the past. We'll have the online class open for anybody who has questions that want to come in. You're not required to. If you don't have any questions, great. But if you have questions, bring them, and we will discuss and help you, so that way you can turn in an incident response plan. Keep in mind, this is a plan. It is not a completed, filled out incident response form. It is a blank plan that you could pick up and that you will pick up in your final assignment and complete. This is just your plan. So these resources here will help the cybersecurity at ISACA, and this other exercise planner will help. So you might want to look at those if you haven't already started or found other resources. If you have questions, of course, about those assignments, you're welcome to email Tim and I before then. But next week, come with questions. If you don't have questions, you don't have to come. We will stay, though, in class as long as there are questions. And that is the end of the lecture. So I covered it kind of quick. I talked fast already, so I apologize. But does anybody have any questions about any of this? Your assignment, your incident response plan assignment, life in general, any questions or anything I can answer for you?
Oh, hello.
Hello?
Oh, yeah, I am trying to ask. You said something, but it's passed over me. I didn't get it. You said about the assignment. If you know about this one, if we have any question, we should come on next week, right?
Yes, next week there is not a lecture. It's just a work day. So it's just an opportunity for Tim and I will be in the classroom or have the online classroom available. So that way we can answer any questions that you may have about your assignment. If you don't have any questions and you're good, then you don't have to come to class. So it's not it's not no lecture. But if you have questions, we just want to be dedicated time to make ourselves available.
Okay. And when are you going to get a response for last assignment submitted?
And Jerica asked that as well. Like I say, Tim was out all week last week. I traveled a lot last week. And so Tim's been sick. So neither one of us have looked at the assignments. We are hoping, the next assignment's due in 2 weeks. And we're hoping to get these graded over the next week. So you'll still have a week before. So we're hoping, but neither one of us have looked at them.
Okay.
Will there be an online discussion for next week or no?
Next week, no. There will be one today, but there will not be one next week.
Okay. Thank you.
We told you this class, we give you everything you need, and it's not the worst class. We don't give you that much homework. And I think most of y'all have found that the weekly discussion questions are they're not difficult. They're at least relevant to the work. Because, we've all taken those online classes to where you go through the lecture, and then when you get to the discussion question, it literally has nothing to do with it and requires a small dissertation to complete. We didn't want to do that to y'all.
Yeah, and thank you for doing that. I have to say that I like the class because it makes me think about privacy from a different perspective than from a technical implementation one.
Right.
So,
And we try to make it practical.
right. Thank you.
Okay. Are there any other questions? I know I went through that quick. Again, a lot of that stuff is more for your knowledge, like the FOIA stuff, the electronic community. A lot of that's just purely for your knowledge. A lot of the privacy by design portion of this lecture and on is going to be more obviously important to your incident response plan and your final, your training and your final assignment. And a lot of that, of course, was done for your privacy impact assessment you just turned in. So, okay. If you have any questions that you just didn't want to ask or you think of something later, feel free to email me or email Tim. And if you want us to look at your assignment 4 that's due in 2 weeks, we'll be glad to look over it and give you some feedback. Come to class next week if you have questions, and we will help you there as well. Again, if you don't have questions, then enjoy your night. Otherwise, your incident response plan assignment 4 is due by 6 p.m. November 5th. That's 2 weeks. I will reiterate, not that I think probably anybody on here has a problem or doesn't remember this, but remember, everything needs to be tailored to the class assignment of Quantum Leap and EWS. So make sure you go back and read that and understand that. But if not, hey, y'all have a great night, and I hope you enjoy getting a little bit of your time back.
Thanks, Jennifer. We appreciate you.
Thanks. Hope everybody, if those of y'all that are sick, hope you get feeling better.
Thank you.